subject to cross-examination. Your Honor has let in, over our objection, evidence under 404B of financial misconduct, and what we're asking is for an order excluding the state from being able to question Mr. Murdaugh on cross-examination matters related to the financial crimes that's been put before the court under Rule 404B if we don't testify about those on direct examination. And we need a ruling from the court at some point in time today before tomorrow. We're not putting them up today, but we're asking that we be able to advise him of what the state will be permitted to go into on cross-examination should he choose to testify, in order for us to adequately advise him and for him to adequately waive his right and his Fifth Amendment privilege and testify or not. And that's what we're asking.
Would you like for me to review with him at this time his right to testify or not testify?
No. Not at this point in time, Your Honor. We have to, we're trying to get an understanding from the court as to the parameters of the waiver of the privilege. Is he waiving, if he testifies about the murders, is he then subject to cross-examination about the financial crimes? That's what we're asking.
All right. Mr. Waters.
Thank you, Your Honor. May it please the court. The extensive dishonesty of this defendant would be relevant if he took the stand anyway, regardless of the 404. So independently, under that rule of the credibility aspect, it would be admissible under Rule 611B. But again, Your Honor has ruled these matters as relevant in the case, and so they're clearly within the scope of cross. Your Honor, citing State v. Gilbert and Gleaton, 273 SC 690, they said right there, as I think the defense recognized, when the accused takes the stand on his own behalf, he waives his privilege against compulsory self-incrimination and must answer all proper questions. Your Honor, Taylor v. State, which I believe may have been overruled on other grounds, but 258 SC 369, when the appellant elected to testify, he waived his right against self-incrimination and became subject to cross-examination like any other witness. And then finally, citing the U.S. Supreme Court, Brown v. U.S. 356 U.S. 148, it says, talking about a defendant in a criminal case, it says if he takes the stand and testifies in his own defense, his credibility may be impeached and his testimony assailed like any other witness, and the breadth of his waiver is determined by the scope of relevant cross-examination. He has no right to set forth to the jury all the facts which tend in his favor without lying himself open to a cross-examination on those facts. Those are the general and well-established rules, Your Honor, and they're particularly relevant in this case, and so we believe that those financial matters would be well within the scope of this particular matter and authorized by the rules in the case law.
Mr. Griffin.
Yeah, just briefly, Your Honor, with regard to credibility, I mean, the rules are pretty strict as to what evidence of criminal conduct can be used to impeach a witness's credibility, and they are limited to convictions, and that's Rule 609. Your Honor has let the financial evidence in under theory of motive, and you've done a 403 weighing test. And Your Honor, I think when you get to cross-examination of a defendant, I think Your Honor has discretion under Rule 403 to prohibit the state from further inquiry, in this case, on the
aspects of truthfulness and untruthfulness, which this clearly goes to, as well as 608C, which talks about bias, prejudice, and any motive to misrepresent. And again, we're not just talking about purely dishonesty and credibility, which I think is alone more than enough. We're also talking about examination on issues that are specifically relevant to this particular case based on the 404 ruling.
All Rule 607, Rule 608, particularly the in advance limiting the scope of cross-examination. Any objectionable matter must be addressed as the evidence is presented and not based on any advance ruling by the court.
Your Honor, the request for the ruling is not an evidentiary ruling. It's the scope of his privilege. And so would he be permitted to assert the Fifth, for example, if they're permitted to ask questions such as they intend to on cross? And that's...
I can't give you any advisory opinions about the evidence and the scope of cross-examination, the scope of his privilege. I'm willing to review with him the scope of his privilege against self-incrimination, if that's what you're referring to.
We will certainly need to have that colloquy at some point at the end of the day, perhaps. But
for the court to issue some blanket order limiting the scope of cross-examination, that's unheard of to me.
Again, Your Honor, I'm not. The question is the scope of the waiver of his privilege when he gets on that witness stand. That's what we're asking for, not an evidentiary ruling.
Well, Mr. Waters has some cases there that I assume he'd like for me to look at, and if you do, I'd be happy to look at what you have as well.
Thank you, Your Honor.
Anything else?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
Let's bring the jury.
In the kitchen in that house are connected, and there were pots on the stove, so Lee Cope and myself and I think Austin got the pots. I think I set something in the sink and they stuck some in the refrigerator.
But when you entered the house, it looked like there was food out that had been prepared for dinner?
There was food on the stove, yeah. Okay. I don't recall seeing any plates, but somebody else could have picked them up. I wouldn't.
But were folks cleaning up?
Sure.
And what time of day was this?
It was probably 1:30 or 2 in the morning.
Do you remember what time you left the Moselle residence on that night, early morning?
I probably left at 3:30 or 4. I left when Alec was leaving.
When did you go back to the property?
I had a deposition the next morning, and I ended up having to take it, and then I got out there about 11, I guess. And
was Alec there when you got there?
I went over to the dog pen over that way. I had gotten a call that morning about 8 o'clock from Randy, 8 or 8:15, and John had gone over there trying to clean up and couldn't.
They, look what they did, is that correct?
Yeah, they, which I didn't really think about at the time until I was taking my wife home. I just thought it was an odd comment.
The sled arrived sometime later?
They did.
Do you remember about how long after your initial arrival sled got on the scene?
I think they came kind of in, because I'm sure they were coming from various locations, but they were there probably within an hour and a half of me being there.
And by the time SLED arrived, were there other members from your law firm and family members out on the property where you were standing?
There were. By the time SLED got there, pretty much all the lawyers in the firm, with the exception of maybe 2 or 3, one of them had small children, and one got forgotten, and pretty much everybody that was a lawyer was there. And family members, all of Ellick's family was there.
Were you directed to leave the area when SLED started processing the crime scene?
Eventually we were. The coroner came over, Rich Harvey, came over and said SLED was there. They were ready to start processing the scene. He said, y'all need to, go over to the house and so I walked back over there and looked around, and then looking around around the floor and all that, there was a piece of Paul's skull about the size of a baseball laying there.
Did that upset you?
It did, very much. I mean, it just really infuriated me. And I don't know who I was supposed to be mad at, but it just infuriated me that this young man had been murdered and there were still his remains there. And there was a large blood spot and tissue out right off of the apron of that area right outside the feed room that was there. And it's kind of like walking across a grave. It's one of those things you just don't do.
Right. After you spent time down at the kennel area, what'd you do next?
I ended up going back to the house, and I remember Terry Brandstetter, Maggie's daddy, was there, and several other people, and I spoke to them and went in the house, and eventually went towards where the gun room was that afternoon.
Did SLED agents come up to search the house while you were present?
They did. They
And I think the jury's seen a video of it. We don't need to play it, but were you present in the gun room?
I was. I think they probably 2:30 or 3 o'clock, something like that. They showed up, and I had a discussion with that same agent. And I'm assuming it's a SLED agent. It could have been a sheriff's deputy, but I made the assumption that it was a SLED agent over at the kennels and the hangar. I asked if they'd figured out what kind of gun it was, and at that time I didn't know. I assumed it was a .223 based on the night before. Barry McRoy had said that he thought it was some type of assault rifle, and I just immediately kind of went there, and that agent had said that it was a three something, and I said a 300 blackout, and he said yeah, and I said, well, there's one over there in the gun rack, and he said no, there's not. And apparently SLED had been there sometime that morning or whatever. He said they already checked, there's not one over there, and I said yes, there is. And so later on when they got there was one there.
So you located it for SLED?
Yeah. Maid had put them up, and so I went and asked her.
Was it Blanca?
And yeah, I went to Blanca, and she said, yeah, I was told to clean up the room, and so I put them up and put them in the rack.
Okay. And did you point out to the SLED agents the guns that were on the table that you thought you'd seen the night before?
I didn't point out the guns. I told them that there had been guns there.
When you're on the property on the, I guess the morning on the 8th at some point in time, did there's been I won't make a statement. Did you see any coolers on the property down there?
I did.
Where did you see a cooler?
When I walked around the bottom part between the skin and shed and the hangar and the other shed, there was a open cooler there, or looked like a Yeti-style cooler, and I can't tell you whether it was a Yeti or not, but it was one of those thicker coolers, and there was probably a dozen beer cans around it that night, and the next day, when I walked by it, it was still there.
Okay.
I just thought it, with all the people and the hoopla that had gone on, that it didn't look very good.
The night of the murders.
It is.
You remember in, I think February 2019, that Paul Murdaugh was involved in a boating accident,
I do.
and you're aware that he was criminally charged,
I am.
and then Alec and I believe Buster were civilly sued.
Yes, sir.
And did you work on the case formally?
Not formally, no. I was about to get in after the murders, along with several other partners.
Did but leading up to the murders, did you have conversation?
After, September the 3rd, I'm not sure I know that person. And so, but he always seemed to be devoted to everything. Their ball games, he would aggravate the hell out of me when you'd be in a deposition and they would call and he'd answer it, and you'd be in a meeting or whatever, and he always took their calls, whereas my wife and my children never called me unless it was a true emergency. And Alec took their calls, whether it was they needed a gallon of milk, or they had something important to tell him. I mean, he always took their calls.
And did you see them together frequently?
I did. They went places. You'd see pictures of them. I think Maggie was a pretty prolific Facebook, text, whatever. I'm not on any social media, but my daughter or my wife would show me pictures of where they had been, or ball games, different things like that. I never saw anything that indicated to me that there was anything out of the way with any of the relationships, including the drug stuff. I had no.
Yeah, let me ask you, were you aware that he had an opioid addiction?
None.
And were any of the partners aware?
You known him for 34 years?
I knew him for 34 years, or I have known him for 34 years.
Thought y'all were pretty good friends?
Thought so.
Interacted many times a week?
We had his son Buster and my daughter were in school all the way from kindergarten on, and I would see him at work. Early on, he didn't work for us immediately. When he came out of law school, he worked for Jim Moss and Moss and Kuhn, and then he came to us about 5 or 6 years after that.
But you've shared a business with him for how long?
Probably 20 some odd years.
He was your partner?
He was a partner.
You trusted him?
You have to, and I did.
And outwardly, to your appearance?
If the judge had ordered the documents to be produced at the June 10th hearing, would Alec have had to turn them over immediately?
No.
That's all I have. Thank you.
Anything further?
If that had happened, it would have set in a process, set in motion a process, though, would it not have?
You're talking
Let me
about
rephrase that question.
If he'd ordered production of all of the documents that were requested,
Right.
that would have been part of the.
Did you prepare? We got the PowerPoint last night about 10 o'clock. When did you prepare that?
Which one?
Was there more than one?
There were two.
Where's the other one?
They were both shown.
Those were two PowerPoints?
There were two separate ones, yes. I take it back. I was mistaken.
You're what? What'd you just say?
I said I was mistaken.
Okay.
There was one PowerPoint. There were two sections to it.
And when did you provide that?
Probably a week ago.
And you just said you were mistaken. You have made mistakes in your life, haven't you?
Yes, sir. I have an eraser on my pencil.
And I'm old school. You're old school. And I don't mean that bad.
Thank you.
And when you were around investigating crime scene years ago, you didn't wear boots.